Okay, we're broadcasting, guys. So I'd like to take an opportunity to welcome all you guys out there who have been waiting. Definitely appreciate it. We're going to give it a few more minutes before, so the folks that have been alerted, can show up. I got with me some folks from National Liberty Alliance. We'll when we get going here, I'll go ahead and do a roundtable, let them introduce themselves, a little bit about themselves, and then we'll keep on getting it. And so right now we got 24. They got 33 people. They're going to start pouring in. So like I said, we'll just give it a little bit of time here, guys, and just let everybody come in. I've sent out the alert a long time ago. Hey guys, how's it going out there? YouTube. Yeah, we're going to let the room fill up a little bit. But for all you guys just joining us, I've got the folks from National Liberty Alliance with us. And here in a minute, we'll go ahead and get the show rolling. I'll have a little round table with them, let them, introduce himself briefly, and so you guys know exactly who it is you're talking to. So I see a lot of familiar names out there in the YouTube. So got Odonata out there modding for us. Thank you, Odonata. Appreciate it. Yeah, we've got a whole bunch of cool stuff. Yeah, we got some swamp speak, guys. Yeah, we definitely have some swamp speak that we're going to be getting into, and so just give us a few more minutes, and we'll kick this thing off. And for everybody over here on the Hangout that's joining us to participate, if you're just joining us and you're not going to be using your audio, you can just reach up to the top and actually mute your microphone and unmute it when you're ready to talk or comment. So all right, so we got 145 people in, and it's still climbing. A few more minutes, people.
Jan, it looks like you made it. Can you say something? Make sure your microphone's unmuted.
Yep. All right, he's muted now. He's unmuted now. Muted. Yeah, Jan, you're muted right now. Now you're unmuted.
Okay, it still shows as muted for some reason, but I'm on. I can hear you. I'll mute out.
Good. You're good. Pilot's muted, and NLA is muted. So, all right, guys, we have 156, 157 people. They're still pouring in. Everybody's just joined us. Of course, I'm on NetCoder. This is a Cooniverse special report. I have the folks from National Liberty Alliance joining us, and we're going to be talking about all kinds of good stuff in a minute. I'll go around, have everybody start introducing themselves, and we're going to be talking about, as the title of this stream indicates, it's a special report. It's about indictments. It's about constitutional law revived, and it's about the National Liberty Alliance and all the great stuff that these guys are doing for us, for we the people. And so, guys, please just bear with us a few more minutes, and we'll get this thing rolling. And over here in the Hangout, do we have everybody here already, Gerard?
No, we're still waiting for John, but he'll pop in as soon as he gets in. And what I'll do is I'll kind of give a rundown on him, introduce him, because he'll probably come in when we're talking.
Okay. All right. That sounds good.
Yeah. I mean, I'm looking forward to having John here. And people have heard me on this venue. I don't think they've ever heard John on this venue, but that's why we're looking forward to getting all us together and sharpening each other up a little bit, revealing what we have discovered in our travels, so to speak. And we're always discovering new stuff along the way. You skin your knuckles in the battle and that, but every time you become a little bit more hardened, you pick up a couple of things, and they keep teaching us things, you know. I mean, we're learning about how they operate and what they do, and the picture becomes clearer and clearer every time we engage with them. And I think they know that every time they open their mouth, they kind of like put the rope around their neck a little tighter, because that's generally what happens with them. Every time they open their mouth, you know, they end up violating some fundamental right of due process or other thing. And that's why you have such trouble getting them to respond to anything, because they understand that they can't answer some stuff. They won't go there. And so generally, I mean, a lot of the time we run into defaults. They'll default rather than answer. And
Right.
then they'll play around with the default and try to get you out on some technicality or lie and say that you didn't notice them properly. And, you know, they got all kinds of rules and regulations, and they want to just, you know, they don't want to talk about the issue at hand. They just want us out of there. And that's generally what happens.
So we'll definitely, I guess, dissect that. I guess what and right now, guys, for everybody that's tuning in, you know, and that wasn't here just a minute ago, we have the founders of National Liberty Alliance with us. We're going to be talking about some poignant issues with regard to, we have some landmark cases that you may or may not know about. We'll go over those. We're going to go over those indictments that are sealed in these landmark. Not sealed, but unsealed in these landmark cases. There's also a lot of other things that have been filed with the courts that you guys need to know about. And so again, the voice that you just heard previous to mine, that's Gerard Apria. He's one of the co-founders of National Liberty Alliance. We're waiting on John, which is the other founder of National Liberty Alliance. So, but we're going to go ahead, I guess, guys, and kick it off. So if we could, for everybody that's contributing, that's here in the Hangout, we'll go around. I guess we'll start with you, Gerard, and just tell everybody, all of our listeners, briefly, you know, a little bit about yourself and why we're all together today.
Okay, well, I'm one of the founders of National Liberty Alliance with John Darash, and we started out probably very close to 10 years ago when I met him, and we met coming together. You know, there was a Ron Paul movement. We were very, you know, everybody was all psyched up over that, and anybody that was part of that understands where that went. And we went from there, we went into the committee man process through primary challenge and a fellow named Lenny Roberto. And we started teaching people the process of becoming committeemen. We did a lot of research, and we discovered that there were no elected committeemen in New York State. And eventually we discovered there were no elected committeemen anywhere, and that they had changed them all into appointed officials so that they could control. So it was quite an eye opener, and we actually reconstituted the elected committeemen in both parties. We redid both parties' rules, and we got as far as we could get. And at one point, you know, and we went all over into every county in our state, and eventually we opened it up to national. You know, we went into all the states, you know, at least, if not physically, virtually through other members that we picked up, and reestablished the committee man. However, just like anything else, you know, they don't accept these things. And so we found that we decided that it was time to sue the Board of Election. So we decided to sue the Board of Election of New York State for some of the wrongdoings that we saw in both parties. It wasn't about Democrat or Republican. It was the parties. And if you look at George Washington's farewell address, that's what he complained about. And I don't want to get too long.
So, right. So let me just, I guess, for people that know nothing about this, okay, effectively, I think what Gerard's alluded to is that as they began the process of National Liberty Alliance, they're realizing that the Constitution, as it's been written, the legal system and how it all operates, it's been more or less subverted. It's been changed up, right? And I think that's kind of what you're getting at. And these are the discoveries that you guys made, I guess, early on with regard to what they did and how they went and did it. And so the committeemen, the fact that they've replaced them with, we'll call them hacks, right? We use the president's term on that, and they get a bunch of hacks in there to do their bidding. So does that pretty much sum that up?
Pretty much. I mean, look at the committeemen. They don't even realize what's going on because they never were educated. So they're kind of just useful. They get them to carry petitions because that's what's necessary. But they hand the names down. You know, you're supposed to. The committeeman's supposed to interview, or wade, if you will, the candidates, and then decide whose petitions they're going to carry. It's not working like that today. What happens is they go up to the top, kiss the ring, they get blessed, and then they hand you a bunch of petitions and say, go out and run these. I mean, there's no vetting at all going on, and no voting for the committeemen, you know, for the candidates. So basically, they took the system that our forefathers designed as a bottom-up system and turned it into a top-down system.
Right.
And by the way, our system was founded on the Mosaic system, just like they did in the Bible with Abraham and Aaron and them. There was groups of tens of families, hundreds of families, and nothing got to Moses or Aaron unless all the people couldn't work it out on a local level. And that's how our committeeman system is run. It's based on that model, whether you know it or not.
Okay, so with that said, you know, is there others joining us at the moment? Yeah, here. Is anybody else joining us?
I don't know. I wasn't watching the board. I don't know if John's here. I'm really kind of stalling for him to get in.
Yeah, I got you. Okay, so this is what I'm going to do. Okay, guys, real quick. We have the founders of National Liberty Alliance, and if you guys don't know who that is, go check out nationallibertyalliance.org. Okay, it's a website, and they have a lot of really, really great information. And definitely take a minute and check them out. What they do is they offer free courses for everybody. Okay, you can learn about civics. Okay, you can learn about common law, which is not technically the law that we're using today, believe it or not. And when you find out that we're not using this law, you're going to have the question like I did. Well, why not? Right? Why are we not using the laws written in the Constitution? And so what National Liberty Alliance does, it kind of gives you, you know, the foundational information that you need to actually learn what this common law is. And the fact is that our legal system, as it is in play today, it's subversion. It's a complete subverted way of looking and I guess translating our Constitution. And there's a lot of people not aware of it. And National Liberty Alliance, when they actually deal with the courts and the attorneys and all that, they can actually see this subversion and these subversionary tactics tried to be applied to their filings. And I think Gerard was saying it perfectly earlier with regard to when they do that, right? They kind of dig themselves a hole each time that they try to, I guess, negate what's written in the Constitution. And this is what is very, very interesting. Even though it sounds like technical legal stuff, it's kind of not. This is we the people. Okay, this is not a group of attorneys. Okay, these are people, right? People like you and me, right? That read and understand the Constitution and know exactly how the legal system works. Okay, guys. So please understand, this isn't about the discussion of law and a bunch of lawyers and all that. No, it is not. What it is that these guys are people that came together as we the people, and they've done some really, really amazing things. And so nobody else is joining us as of yet, Gerard. So
hey, Coder, he's saying, I have no idea, no clue. It wants me to sign in. He needs a Google account or something. If he doesn't have a Google account, how could he get in?
Yeah, I'm not sure because I've not run into this, but I'm fairly certain with the help page that what's his name sent me. He said he was getting that help page because he had not logged into his account or something for a while. So I don't know.
Gerard, if you want, I'll go over and work with him on Skype.
Yeah, he's on Skype right now. I just noticed he sent me a message, and I told him I'd ask here. So if you could do that, I'd appreciate it.
Okay, great.
And you know, he might have an account because he has YouTube accounts, and I think in order to have a YouTube account, you got to have an ID, and I think that ID would probably be good enough.
Right, right.
I'm
got
guessing
you.
Anyway.
Right. And so what I'll do, guys, is you know, for those of you guys watching, I just pulled up the nationallibertyalliance.org website. Okay, guys. So if you come here, the website itself is free. And I think like the free courses, all you have to do is just sign up for their account, and they have these free courses specifically. Okay, the free civics course, right? This is what they're removing from the schools today, right? So anyway, what's really great is National Liberty Alliance actually have a free civics course for you. Okay, and trust me, it's not a boring course by far. You will learn more about our Constitution. Okay, and they have effectively the course directions and the constitutional course itself, right? Which is really, really awesome, guys. You really need to take a minute and not only look at this, but share this with everybody you know, really, because people need to know this stuff. So you have the free constitutional course. You also have the government by consent course registration, and you also have a free common law handbook that you can get. So you want to give us a little insight in this government by consent course registration?
Yeah, you know, we offered a free Constitution course and a free civic course, and right now John's doing a big master course that's going to include everything, going to get more into the nitty-gritty of actually how things are done, you know, and by the time you get done with that course, you'll know everything. You'll be able to run a case. You'll also know why and where we came from. You know, if you look at what we have there now, we have works by all the great guys, and some of the ones that blew the horn early on, and they're absolutely 100% accurate today. So there's a lot of video and multiple choice. The civics course, it runs over 100 hours. I think it's 120 hours. The Constitution course, you could do it probably in 6 if you wanted to sit there for 6 hours. But just by doing those two, you will have more knowledge than 99% of the people you meet in the street.
Wow, that's great.
And that's going to really empower you. We also have a handbook for you know, juries and people on the, you know, which basically it's like one of those little Constitution book, but it goes deeper into the jury, the grand jury, sheriffs, what they should be doing, you know, and that explains that. The other thing that we did come up with was a thing for the sheriff. We actually have a complete site that is geared just towards the sheriff, and that's powerofthecountysheriff.org. And that's and there's, I'll tell you what, it's almost as full as our National Liberty Alliance site as far as resources and free books and downloads and stuff. Really, I mean, you could just go perusing around there for a long, long time, pulling information out. And we have a lot of audio, you know, trial by jury, that type of stuff, really good stuff. And basically, you can get a full education on there and never leave the site, you know, as far as what is there. It's massive. But there's also breadcrumb trails that lead you through, you know, the timeline of what's going on. And even our cases, if you read the cases that we file in the court, they are so instructional. Everything that's going on, we mentioned, because basically by putting these cases in, we are educating. Part of it is to educate even some of these useful idiots up there that don't understand. And we're going to, and I mean, I hate to call them idiots, but, you know, their actions are speaking louder than anything else. They need to educate themselves, and our cases are designed to do that. If you read the case, make sure you read the footnotes, because, you know, when we're doing a case and we have a footnote, you go down and it'll explain a term or a word. And I got to be honest with you, most of what is put in these cases are not our words. Okay.
Right.
They are the words of the Supreme Court, of our founders, of our forefathers. And I mean, look, we put our 2 cents in too, but, you know, we do a lot of quoting because those are our authorities. And we have a guy that teaches, and he says he's found this saying, "He who never quotes will never be quoted." So we do a lot of quoting, and it's very profound, especially when you when you apply the quote where it belongs. And that, you see, people are not getting this education. And I got to look at our forefathers did all the work for us. We don't have to be so smart. All you got to do is learn them and repeat them. People will think that you are amazingly smart if you just learn them and learn to apply their words in the proper place. People have never heard them.
So let me ask you this then, Gerard. Okay, so, we're just looking at, I guess, the starting page of the site. And, as I'm scrolling down, there's quite a bit of information. And one specifically is learn how to write, file, win in court in 90 days or less. Okay, so that link right there is pretty appealing, I think, for a lot of folks. But again, in one of our previous conversations off air, you had made mention that a lot of people have been taught to believe that you need to have some kind of a legal license or something to actually be able to go into court and or file stuff. Is that how true is that?
Well, that's what they want us to believe, but that is definitely not true. There is actually no license to practice law, and the Supreme Court has said it many, many times. But look at a lawyer that has a license is only licensed for people who are minors or who are something's wrong with them. They can't fend for themselves. They have a disability. So a lawyer can speak for them, and he needs a license to do that. If they're not of normal, if they're a minor, a child, or they're all elderly and they have some senility problems or whatever, that's the only license that there is.
So with that said, okay, we're, everybody, I guess, since you're old enough to know better, but everybody tells you, oh, well, to do this, you need to get a lawyer. To do that, you need to go get a lawyer. To do this, you need to go get a lawyer. Or if you happen to have a traffic violation that's kind of ballooned a little bit out of control, then you should probably get a lawyer. So with all that said, right, this is really not true. Is that correct?
Absolutely not true, because the courts are open to the people. It's guaranteed. And really, in many of these cases where we're going in being violated in our basic principles, they're not even supposed to charge you. They cannot take money to perform justice, but they do, and they get away with it because we don't correct them. And I want to bring in that court access without a lawyer course, there is a course called jurisdictionary. That is not ours. That is a course that John and I took early on, and that teaches you. That is written by a lawyer for people that want to run cases in court. So even one of their own members knows that you can go into court yourself. And so, it used to be everybody knew that, but that's $249. And actually, if you click it off the site, we make something off it. I don't know. We make $40-50 if you buy it off our site. But that's a course that just gets you familiar with the rules as far as when to write a motion and how to write a motion. But the rest of what we teach is what they don't teach, because he'll tell you in this course, don't use the Constitution, use the statutes. They don't like to get involved with the Constitution because statutes are so much easier for them. It's like a nice card with holes in it, and you stick it in, and if everything lines up, you get the result. That way, they don't have to work too hard. They don't have to write anything. You know what I mean?
So it seems to me that, okay, what we're talking about is they're teaching this way of doing law, which the way of doing law is really the subverted way of doing law as depicted in the Constitution. And so you either do it their way and do it by their statutes, and of course they've removed the ability in basic school to learn the fact that we are under common law. That's what our legal system is, but they've really not and purposely not really shared that with anybody. So in my mind, I mean, wouldn't that be considered a treasonous act if done by somebody different?
Look, it absolutely is treasonous act. Matter of fact, when John comes in, when he gets in here, he's of the opinion, because of what we've discovered about what they're doing as far as how they're keyholing us into this statutory court and trying to make it more of a contract, that they can manipulate than on constitutional principles and an Article 3 court under the Constitution. They don't want to give you that. And so he's of the opinion that we need to sue the judiciary and the bar. And the bar is teaching the judiciary and all the lawyers this stuff that is basically anybody that teaches treason is committing treason.
Exactly. That's what I've learned. Right. Exactly. So in my mind, right, for our listeners out there on YouTube, right, when it, because all we know is what we know. Okay, that's all we know. And so at the end of the day, the legal system as it's being run today, right, is what we've been taught. So what we're hearing, right, is that the legal system as it's been defined in the Constitution is completely and utterly different than the subverted one that everybody's forced to run under today. Is that safe to say in a quick summary?
Yeah, basically. Kind of lost my train of thought there for a minute, but what they're doing is just give me a minute because I was typing something to John and I lost my train of thought here trying to get him in.
Right. It looks like he might have joined us. Hey, John, can you hear us? Okay, he's muted.
Okay, unmute.
Am I unmuted?
Yeah, you're unmuted now. There you go. Okay. Good job.
Right. Okay, repeat that question. I'm sorry because I was typing and I didn't get all of what you asked me. Go ahead.
So I guess what I'm asking is, let me make sure these levels are right, guys. All right. Yeah. So what I'm saying is what everybody's being taught, like the YouTube listeners, they may know zero about law, like me, right? I know a little bit about law, but really zero in comparison to others. But what I'm getting at is it safe to say that the law that everybody's been taught and the way it works, they're just being taught the subverted thing that's in play today, and they're purposely not being taught, I guess, the real law, which is our common law as defined in the Constitution. Is that safe to say in a quick summary?
Oh yeah, it should be simple. It does. Lawyers want to make it complicated. The statutes are complicated. They're twisty, turny, they suck you all over the place. And really, common law it only takes the heart to know right from wrong, and it should be. And when you read the stuff that we're writing, it's basically done in a common law manner. It's interesting and it makes sense. There's nothing confusing about it. Like you said, you don't need a special degree.
Can I clarify one thing?
What's that?
Can I clarify one thing?
Yeah.
INET Coder. The Constitution was written under common law to be used with common law. It wasn't the other way around. So I just heard that. So thank you.
Both the Constitution and the Bill of Rights are common law documents. And when you go into court and the judge tells you, like the chief judge in New York told us that the common law has been abrogated, there's a treasonous statement. That means the Bill of Rights and the Constitution have been abrogated, if you really want to take it to what that means. Absolutely. Man, that's impossible. And that being said, lawyers go to law school, and when they come out, they don't know how to run a case either. You have to work under another lawyer to learn the procedures and the court rules and all that. They don't teach them any of that. That's a craft. That's, it's almost like you got to apprentice, just like a mechanic's apprentice. So they don't teach you that. You have to learn that through other people, and you learn it as you go through the course. Now, we the jurisdictionary course is basically what helps you with a lot of that they don't teach, when to do motions and this and that. But, the more we're in court, the more we learn about the process and procedures they're using. And the more you know about common law, you also see where they're subverting the Constitution and disobeying it and really going opposite to what they're supposed to be doing. And like we discussed before, with the bar and the judiciary, they're committing treason because they're locking us out and they're denying us and they're making law from the bench and they're producing all kinds of crimes up there, in the courts. It's
so
really
with that
disgusting.
So with that said, okay, I know that you guys have filed a whole lot of stuff, and that's really awesome. And I'll get John in here in a sec. But with everything that you filed, and it seems like with the way that you go about the filing, they actually have to respond within a period of time, and sometimes they do, sometimes they don't. But when they do respond, doesn't it more or less put them in a position where they're actually admitting that they're actually committing treason? I guess, John, I don't know if let me test your audio out real quick, but does that sound pretty accurate?
Yeah, if you could repeat that.
Yeah, I'm just saying that. Yeah. Can you hear me?
Yep.
Okay. Yeah. So the question is, as you guys file different things, and the court has so much time to respond, and when they do respond, they're almost, I guess, in their responses, they're almost kind of like admitting to the subversionary techniques that they're kind of trying to enforce on everybody. Does that sound accurate?
Well, yeah, pretty much. You know, you got to understand that most law is constructive, and there are about 49, maybe exactly. I know we did a study on this, and I think the number is 49. There are 49 different courts recorded in Black's Law Dictionary. So when people read the information in Black's Law Dictionary, they got to keep that in mind and understand that. So they got to, you know, apply the proper court information, procedures, process, whatever you want to call that. Now, the common law is really made for the common man. It's God's law. You don't need, there is no construction per se, although there's nothing wrong with creating particular forms, and let's agree, hey, let's use this kind of a form to bring this information out, or this kind of a form to bring that information, such as mandamuses, or writs of mandamuses, or other writs. Let's have some rules, and let's do it this way and that way, and that's all good and fine. And it will help to bring order, put everybody on the same page, and do different things, especially when you go into an equity court. And there are only two courts you can go into here in the United States. One is an equity court, and the other one is a court of law. And maybe I'll try to define the difference between the two in a while. But the key thing is that you're going into a court, and it's not required of an individual to have to understand the construction part of the system. The Supreme Court has ruled numerous times, and logic tells us the same thing. The only thing necessary for a prima facie case is an affidavit. That's it. So if you have a sworn affidavit, you tell your story, that's all you need. You need know nothing else. You need file nothing else. Although it is, if you're going to go into court regularly and often, it is good, especially if you're making points and going into equity courts particularly, you know, you want to follow some rules, but it's not necessary. Now, the rules in our courts have been was originally put together by Congress, and I forget what year that was in, but it was quite some time ago in the 1800s. The rules of the court were put in, and the lawyers complained, you know, and remember there was a huge number of bar lawyers that were sent to the United States in order to disrupt our process, to disrupt the courts, to disrupt our political process, to disrupt our legislation. And that's where you get all of these things. They've made a construction of law. And this construction of law through the legislature is really what has put us into what's called a statutory prison. And that's where we're at. Now, when you go into court, you know, if you're going to go into a proper court, you're going to go into a court of law. And now you can use, basically, let me give you a basic difference between an equity court and a court of law. A court of law is pure 100% natural law. It's which is also called common law. They've been calling it common law since before the Magna Carta. And the meaning between common law is a law that is common unto all men. Lawyers will try to have you believe that it has something to do with common court, you know, using court cases and making that the common conversation and the common decisions and the common conclusions and ideas. And I mean, that's a lie from hell. It has nothing to do with that at all. And so it's what's common to all men. It's the law common to all men. That's the key point here. Now, when you go into a court of law, okay, you then get a jury, and it's called a court of record. The court of record is the most powerful court in the world, in our nation anyway. Once the decision is made, it cannot be overturned. You know, you get these decisions where a jury came out and they made a decision and they tried to appeal it and so on and so forth. I don't know that they ever get through the appeal, and they shouldn't, because they've said the final word. The only thing that may be able to be appealed, and we get this, I think, in the Seventh Amendment, it must proceed according to the rules of the common law. And you may get an appeal. Well, you should get an appeal if someone's unalienable rights was violated during that process. Then you can get an appeal. If somehow the individual who was being accused of something, who was the defendant, and was convicted of something through a violation of their unalienable rights, then of course that can be overturned. But other than that, the decision is final, and you usually won't find that unless lawyers get involved. But did you want to say something?
Yeah, I was just going to say that we've actually seen that play out, right? Where, we'll just say the prosecution, right, of the state or whatever, they've falsified or misled or kept evidence, from the defense, or so we actually seen different things overturned because of that. That's kind of what you're alluding to, right?
Well, yeah, generally speaking, but all those laws, all those court systems that you're talking about, on these court procedure systems, they have no power to fine, they have no power to incarcerate, yet they do, and they do only because we allow them through our ignorance. If we were not ignorant to this, if we were taught in our schools in one accord, we would step up and say, foul, that's a fraud, no way. But we're not taught these things in our school. It's been eliminated from our schools, and we're programmed in our schools. And that's going to be one of our next projects. As soon as we get into the schools and set up the committeeman thing, we're going to start moving. I mean, get into the courts and take control of the courts, we the people, and get the committeeman program started, sparked up. Then the next step is to move in for education to our children in the lower grades right up into the higher grades. But going back into the system, I remember when we were learning through the program that Gerard had mentioned, Juris Dictionary, which if anybody wants a copy of that, they can go to nationallibertyalliance.org, and I think you'll find it on the right-hand side, Juris Dictionary, court access, that kind of thing. And if you go through that, I think it costs $249 for the course. It's well worth it if you're really trying to figure out how the court system works, technically speaking. And you got to learn common law, and you got to learn proper procedure. You got to learn the truth of things, because you're really being taught by a lawyer. But he is a pretty good guy. He's trying to do the right thing, but he's still lost like the rest of them, and he chokes on truth. But in any event, one of the things he mentioned, like particularly going into the federal courts, which was a big error in what he had said, is try to stay out of the federal courts. Well, those are the courts we really want to be in, because those are the courts where we battle for our unalienable rights. Those are the courts we take argument against someone like a governor, or maybe the legislators of your state, like we're doing here with the gun issue, the Second Amendment. So you want to definitely be able to go into a federal court. Now, what he said was that when you go into a federal court, the big problem is that jurisdictions change as the conversation moves forward, and you have to be aware of that. Now, that might sound kind of complex, but it should be pretty easy. And if we can get rid of all the fraudulent legislation and destroy that, burn that up, get rid of that, then really it's not too difficult to see what jurisdictions you're in, because there's only a few jurisdictions that they have authority to go into. But they do go into jurisdictions unknown. The rules of the court, well, like I said, were originally written by the Congress. And the Congress, the lawyers were complaining. Of course, the minions were coming into our nation, and they would, causing havoc everywhere else. And eventually they had the American Bar Association. And so we had our homegrown terrorists here. They didn't have to come in from outside to destroy our nation, our Constitution, and everything else we got going for ourselves, our morality, and so on. But anyway, what they've done is they have taken control of the rules, where the Congress says, well, okay, fine, look, why don't you guys write your own rules? Now, they gave that to the United States Supreme Court, the power and the authority to write their own rules. And now I'm not sure exactly how that went. I don't know the part of the history of the actual mechanisms or the process that they used. I'm presuming what they did is the United States Supreme Court probably passed it out to the federal judiciary. We have 94 federal districts, but back then we had less because there wasn't as many states. But in any event, they got it. That's how I think it went. So the federal judiciary probably got it, put it together, and that stamp of approval needed to be approved by the United States Supreme Court, which somehow they got the approval on it. But what they did is they hid a lot of things in it. They do what's called legalese, and if you're not expecting it to be there, you might not even see it. And so the bar attorneys got in there and they wrote all kinds of certain rules and different things. And then it's changed over the years. They've made some amendments to it, and it just gets worse and worse and worse. Now, these are federal rules of civil procedure right there. What that tells us, statutory. It has nothing to do with equity, although it's equity in the sense of what's called chancery law. There are different kinds of equity courts. And these equity courts, depending on which law you're working off of, then there's an equity court, particularly for chancery. Now, chancery courts was what the king used in order to try to convict, our founding fathers, and they were shipping people to England because they couldn't get convictions here. They couldn't get an indictment to begin with, and so they would what do they call them? Bag them and take them out by ship to England, and 3 months later or whatever, they'd find themselves before what's called the Chancery Court. It's a court of statutory process, and and then they go through whatever it is they're going to go through. Now, what happened was that the people didn't understand that, and there were some Chancery courts brought into the United States, but they were banned by the Constitution. Now, in the Constitution, the language that really got rid of this can be found in the Bill of Rights to begin with, which requires the rules of common law to be applied and not the rules of chancery. That's number one. But remember, the Bill of Rights wasn't written till and approved till 1792. Okay, but the Constitution came out in 1789. And within a couple of months after the Constitution, the legislators came out with their very first, one of their first decisions or acts, and it was the Judiciary Act of 1789. And what that did really was frame out the authorities, the processes, the procedures, how people can be chosen for this office or that office. And of course, they still had some blank spots in between that they wasn't clear on, and Marbury versus Madison cleared a lot of that up. But what happened was, in that process, they put in there a statute. Okay, let me see if I can find that and kind of just read it, which really has destroyed us, because it brings us right in to the statutory process under the fiction of law. But it's section 15, where it says that, that the procedure is done by the ordinary rules of the proceeding in chancery. Now, that's the rules of chancery. The Constitution forbids that. Now, going back to equity, equity court or the law, or whatever you want to call it, because the Constitution refers to the law and equity. Okay, so both of those type of courts can be open. But remember, we are a common law nation, so it must run under the procedures, the process, and the rules of common law, no matter how you get there. Now, equity courts are really mostly, debates or arguments between two individuals. Usually contract laws, whether they're written, contract arguments, whether they're written or verbal. You go in, you can battle your case out in an equity court, and you can agree to having a political or a what would you call them? In the case of the federal, they're appointed, and to some degree they have a political background because they're appointed by a particular president with a particular persuasion. But in any event, that you can agree to go into the courts and let one judge make a decision, and that speeds up your case. And if that judge is righteous and following the rules of common law, the right person will win that case. They have the opportunity to then challenge that decision, and they can appeal it, and they go up a couple of levels of appealing. And in some cases, of course, you can get all the way up to the United States Supreme Court. Now, remember, all the rulings of the United States Supreme Court only applies to equity courts. It does not apply at all in any shape or form, so to speak anyway, to the courts of record, because we are the creators of the law as far as our constitution or a nation is concerned. Then the common law is written by God. It's in the hearts of all men. But but we were given the power and authority when we covenanted with God through the Declaration of Independence, asking for His unalienable rights of liberty, and He blessed us with those liberties. We read about that in the preamble to the Constitution, and so He blessed us with that liberty to come into His courts to maintain and have our liberties and to be under His law. Okay, and His law does not require licenses and permits or any of those things. And it's very plain and simple, and to put it in a couple of words, it could be simply put, common law is do no harm. That's it. Nothing more to it. It doesn't get any more complex.
Right.
So anyway,
going
back. Yeah.
So let me just interrupt you for a moment, if I could. So a lot of the folks that are listening right now in YouTube, they may or may not know a whole lot about law. They may or may not know exactly everything that is, I guess, being discussed. So what I would like is, because I know for a fact you guys have done some really, really wonderful things, and I'll just give you a quick background briefly, and that is, I actually ran across that landmark case that you guys had filed, and I actually began talking about it. I don't know, it's been some months now. And I began talking about it, and I was invited onto a live stream in which that discussion kind of kicked off, and I kind of brought it up, and it just really, really blew up from there. Okay, these people did not know that you guys even existed. They didn't know that you guys had filed this landmark case in the court. They did not know that all of the people that had been mentioned were under these types of indictments. And then I guess the question marks started popping in everybody's head when you start saying, okay, it's been filed under common law, and you've got some people out there that says, oh, well, that'll never work because we don't have common law anymore, And so that just got me really motivated, because I notice that the Constitution is still written as the Constitution's been written, and same as the Bill of Rights, right? So that's not changed. And so it was really curious to me, and of course talking with Gerard, it's very curious to me on how these subversionary techniques go on, number one, and number two, how is it that nothing's really been done about it until you guys show up on the scene? Is it just the ignorance part of it that really prevents us demanding, right, that we the people are really the leaders and the owners of these courts, and the judges, and any attorneys that may be there?
Well, you got to remember that in order to maintain a slave and keep control over your slave, you got to keep them ignorant. That's the key. You can't learn to read, can't learn to write, they can't learn about freedom and liberty. They only could know what they're being told, and what they're being, the thumb of suppression is upon them. But we have a problem in this country, and you've just said it. The people don't know, and they think that this isn't no more, or you can't get this, or you can't get that, and that's ignorance. The good thing is that people don't know about the law, because if they knew about the law, they'd know what they're being taught out there, and it's nothing but garbage, and really brings you further down the rabbit hole. When we write our papers and put them out there, people with no background, no understanding, nothing, if they take the chance, and because they've been trained. Remember, we've all been trained. If you got to go to court, go get yourself a lawyer. If you got a problem spiritually, go find yourself a priest. I mean, nothing could be further from the truth. God doesn't want you to come in to Him with a priest there between you and Him. It's between you and God, and we shouldn't be putting lawyers into our courts to make the decisions for us. The Constitution gives us the ability to have counsel. and access to counsel, but doesn't mean that someone should represent us. Now, if we can't articulate ourselves well, maybe we might want to have our counsel do most of the representation, but we've got to make sure that they bring forth our will and they're really working for us and not them, because that is the process. Everyone in the court, all the officers in the court, you got the prosecutors, you got even your lawyer. If you come in with a lawyer, your lawyer and the judge, they all owe allegiance to the powers that be, so they have to obey the judge. And the end of the day, they want just the status quo to be maintained.
Right.
Now,
right.
people read our papers that have no background. They get it. They may have to struggle with a few things, but they get it, and they read through it a second time, and then they start to look in footnotes, and if they read it over and over again, they'll really get it, and they'll get more and more food out of that each time that they read through it until they get a really good understanding. So it's an education in itself. But any lawyer that reads it, without fail, completely, they puke, they throw up, they can't handle it. It's too much for them. First of all, well, because the main thing is it denies everything that they are and who they are. It denies their knowledge of the law. These people think that nobody else could know or understand the law but them. You have to have this high education. You have to have specialties in this law and that law. And you can't just walk in here. You don't know the procedures. You don't know the process. You don't know how things work. I went to school. It cost me maybe $100,000 or $200,000 to go to school. I got this investment in time, my investment in money. I had to pay off my loans, et cetera, et cetera. They got a lot invested.
Right.
Okay. So the first thing they do is start puking, and they just can't bear the truth. It's like the devil looking at Christ. They just can't bear the truth. They can't look at the light. It hurts.
That's real interesting, man. Yeah, that's real interesting. We have got a question out there, if you don't mind. Why does Congress pass bills? Is the first one by Specter. He works with us at Qniverse here. And why are people charged with crimes?
Well, look at again, who charges you with the crime? Ultimately, in the statutory process, quite literally, the prosecutor has total control over that. But they're supposed to get the permission of the people. Okay, they're supposed to go to the grand jury and ask for an indictment. And the grand jury that they have, every grand jury out there, and every trial jury is stacked. Okay. Right. They have these questions that they ask them. If you ever read the federal questions, for me, I was just like, I couldn't believe the questions they asked people. Do you watch cop shows? Do you watch CNN or do you watch Fox? I mean, who are these people? Who wrote this? Right. Well, we happen to know who wrote these last rules, by the way. It was Clinton and what was that attorney general's name?
Eric Holder.
Holder.
No, the one that worked with the woman that worked with Clinton.
Lynch.
That's it. Those two people wrote the latest federal rules, so it kind of sort of tells you.
Yeah.
But if I could, let me give you some more structure first in history, so that the questions, it'll work out better and solidify better within your brain. Sure. But going back into the courts, that's the most important thing, to understand the difference between equity and law is the first point of order. And now equity has to operate under the common law ultimately through what's called American jurisprudence. Now, American jurisprudence was generally pretty much written by the United States Supreme Court. And most of it has been written when the United States Supreme Court has been pretty pure. Rarely did stuff get into the, if any, and I haven't found anything in American jurisprudence that was really seriously defunct. So, I mean, so they did a pretty darn good job. And if you go through the American jurisprudence, you'll see that it's pretty on point. And what American jurisprudence ultimately is, and the purpose of it being written, was to control the judge's behavior and to maintain the judge's rule of order through common law. So he had to operate according to the rules and things that were laid out through American jurisprudence. They have to run their decision making according to what they learn in American jurisprudence, instead of these judges making their own mind. I mean, President Trump did not really understand what he was doing when he had to make an argument with a federal district court, which is a peon, has nothing. They look at whatever they say is irrelevant. They don't control the president of the United States. First of all, we have the separation of powers. The president should have told him to go to hell.
Right.
But he didn't know that. He didn't know that, and that's okay because he's not. None of us know everything, so he's got to work it out. But anyway, what that judge did, he had no power, no authority. Unfortunately, we didn't have a Scalia up there that might have got involved and done something like he did with Bush, okay, when the voting thing was going on. But you know, if we had a Scalia up there that would have stepped in and stopped all that nonsense, then he wouldn't have to go through all the changes he went through and waste all his times in order to do what he wanted to do to protect the borders of the United States. Look, he's got a job to do. The law is quite clear. And he should have told the court, you can't make law to overrule that. This law is clear. Go to hell. And he should have enforced the law and moved on. And nothing would have happened because they couldn't do anything to him.
These subversionary techniques are crazy, man. And John, I can tell you, man, you guys are taking it on, I mean, like head on. And kudos to all you guys, seriously. And Gerard and I, we've had a lot of really good conversations in the past on this, you know, very topic. And I know a lot of YouTube folks out there are saying, yeah, really, what can I do? You know, can I do something to help?
Education,
you know?
Absolutely. Look at people need to first come out to the website. They should read our front page, watch all the videos on our front page, and then make a decision if they feel that we are worthy of their support, either by joining us as a member and getting behind us, putting their shoulder to the door with us to break in, and or support us financially. And I know some people, you know, they don't have a lot of money, but we don't need a lot of money. We ask people to give us $5 a month or more. And 99 point whatever percent of the people can easily give us $5 a month or more. You give up a bagel and a coffee once a month, and there's your $5, you know?
Sure.
So, you know, everybody could do that. And some people have done that, and some people have done better. And there are some people who really can't do it. Maybe they're getting on Social Security, getting $800 a month. I mean, what are they eating? Cat food? I mean, it's really rough, you know? So, I mean, those people, whatever, we don't push on those people. And our last course that we're writing, which isn't open yet, we've got 3 courses up online, but the third one is in the process of being put together. But when that third course comes open, it's the only one that we're going to require that people become a financial supporter of $5 a month or more, because we really need the money, and people need to put their money where their belief system is. And if they believe in what we're doing, and they believe that we can put out good courses and good information, and that we can teach them these good things, how to take control and give consent to government, then of course they should support us financially. And $5 a month or more is not a lot to ask. But if people come in and they can't afford it because they're on a limited income and they really can't afford the $5, and believe me, there are people out there that really can't afford the $5. Not that many, but they're there. So those people, you know, we should, what we do is we allow them to come in for free, because we don't want to sell anything, okay? Right. We call it a free course anyway, but you have to be a supporting member at $5 a month or more. But going back to the cases and getting back to equity and how equity works, judges must rule according to American jurisprudence. And, you know, the United States Supreme Court, I'm kind of disappointed in them. And even when Scalia was alive, God bless his soul, when he was alive and pushing things, you know, maybe he couldn't do it because the gun was to his head. But look, all this nonsense should have been stopped by the United States Supreme Court. As a matter of fact, one of our next moves, the papers that we're filing on our Second Amendment case, we're going to be filing 2 papers, very, very powerful papers, very, very good educational papers that explain a lot of what we're talking about right now. And it's a brief of amicus curiae, if I'm pronouncing that right, which is being written by the Unified United States Common Law Grand Jury, coming in with the authority of the King's Bench in a court of record in support of the plaintiff. So we're coming in as a next friend, or the sureties of the peace, to the people. And we're coming in to put our position and thoughts and ideas into the Second Amendment case, which was brought by people, mostly members, but not all members, of National Liberty Alliance, who came together to file this lawsuit concerning the SAFE Act and all these stupid gun laws they have. And then so now, Now that they're breaking the law boldly, they've broken 5 different major positions, even their own rules, misinterpreting their own rules in order to get their own positions and maintain status quo. Well, then now the grand jury is going to get involved, and we're not going to tolerate it. So the grand
Very
jury is now coming in with a position of a paper. These 2 papers hopefully will be filed tomorrow. We do have them. We're working on perfecting them. We started perfecting. We got one of them perfected, and the other one we'll try to perfect tomorrow. Maybe we can get it out. We'll definitely get it out by Saturday, but we will go out. And one of the things we're doing is we're copying, of course, Jeff Sessions, the Attorney General. We're copying the Senator Grassley, who is the leader or the chairman of the Judiciary Committee. We're copying President Trump, and we're going to do a special copy to the United States Supreme Court. And in our copy to the United States Supreme Court, we're going to make the point, we're sending them what's called a writ of mandamus. And a writ of mandamus means we command you. We're not asking, we're not liking, we're not wishing. No, we command you. And we're going to command them to support the Constitution, to force these judges in these federal courts, particularly in this case, to obey the Constitution, to correct themselves, and we're going to go through indictments on these people. I believe we'll get indictments, we just bring this up to the grand jury, and I'm convinced that they'll indict. But in any event, we command you, and what we're commanding them to do is to write a writ of mandamus to this particular court, which is in the Northern District of New York, up in Albany, New York, in the county of Albany, New York. We're commanding them to command them, okay? We're far above all those courts, and we're above the United States Supreme Court. And Scalia has made that clear in United States versus Williams, which I'm sure Gerard has mentioned probably a few times on this channel here. But we're going to command them to obey the law. And if they do not, which they are in bad behavior at this very moment, okay, pending potential indictment, okay, and if you don't command them to obey the law, then they're going to be guilty of breaking the law and also subversion against the United States, particularly against the Constitution, warring against the Constitution. Right. And so that's where we're going with this particular paper. But getting back, let me drive back to equity, okay? The United States Supreme Court rules in cases of equity. We're not in a case of equity, but nevertheless, it's a court out of control, and they need to put these people back under control. It's their job, and you can read about this in the Constitution, that it's their job. In Article 3, Section 1, the judicial powers of the United States shall be invested in one, not 2, not 10, not 94, 1 Supreme Court. And in such inferior courts as Congress may form from time to time, ordain and establish. So they're inferior courts to who? To the United States Supreme Court. The United States Supreme Court is their boss, okay? I remember going into a court down here in a state court here in Dutchess County and arguing with the judge, and he was going against the Constitution. And I told him, I said, look, at the United States Supreme Court has already ruled on these things, and they said such and such and such and such and such and such, and you're going up against the United States Supreme Court claiming something different. And he started arguing with me, telling me, oh, no, I'm not going against that, this or the other thing. But of course, I didn't know how, and I didn't understand how at the time. But I understand now. I was in the wrong court, and they had squeezed me over into a civil court. Even though I opened a court of record, they squeezed me over into a civil court. And like I mentioned earlier, courts, when you go into a federal court, jurisdiction changes with the conversation. And the last conversation that is had changed the jurisdiction to another jurisdiction. That's the jurisdiction you're going to rule in, and that's why and where they feel safe. We're exposing that in this case. We're using this as a case really to go after the judiciary. Now, what we need to do right now, and I was talking with Gerard about this earlier today, I think it was, or yesterday, is we need to go after the judiciary now. We can't afford to wait anymore. We came into the courts with that intentions when we came into filing the case, which we filed about 1.5 years ago, which, by the way, is not a case. The case that we filed, where we have all these documents in by the grand jury, is really a depository, because you see, we tried to get access into the courts, but first on the state levels and the Supreme Courts here, to get in as grand jurist and as trial jurist. and they denied us access. Then we moved over as time went on to the federal courts, and we couldn't get in there. They deny us access. They deny us access to our jurisdiction. They deny us access to our courts of justice. They deny us access to the law. And so we said, okay, fine. These are, extraordinary times. So we're going to have to set up tent outside the court and operate as a grand jury, as we the people have a lawful right, unalienable right to do. And so that's what we did. And then we realized, well, okay, after we served all these papers on all of these individuals, we served papers on the U.S. Senate, the U.S. Congress, we served papers on the president, we served papers on the judiciary, the federal judiciary, all federal judges, all 94 districts, we served the papers on them. We served papers on the state judges. We served papers on all the governors in every state. We served papers on both houses in all 50 states. Over a period of time. We serve papers on the sheriffs. We serve papers on everyone and anyone of authority. And we exposed to them the subversion that was going on in America by enemies, both foreign and domestic, operating within our governments. Governments, every state and the federal in our governments. And so that's what we did. We put that out.
And so let me ask you this, man, because I have actually been to your site. I'm an actual member, of course, and I have been reading the materials. And I understand that you filed all of these filings under one specific case number, which is...
So that's what I was getting to. I was getting to how we came about to that.
Okay.
We filed these in all the courts, all 94 district courts. All these papers we filed, and nothing stuck. They ignored us. Nothing. So we said, okay, what's the next step to do? Well, we got to get into the court somewhere, because if we're going to operate as a grand jury especially, we need it to be under the auspices of the court. So the only way to get into the court is to open up a case, and it is a civil case. Well, we made it clear this is a common law procedure and the process of what we're under, and ultimately that this has become a depository. They've accepted our paperwork. They continue to accept our paperwork to this day. We just filed I just sent papers out 2 days ago. We had papers that will go out 2 weeks ago. They don't return them. The clerks are afraid to return them now. We've already indicted one of those clerks over a situation. So they're afraid to return them. The judges dare not put their fingers into the files, pull it out, and send it back to us, because they want the clerks to do that. For them, it's 20 years in jail. Their statutes. And that is a righteous statute. It's a statute that Congress had the power and the authority to write. That's what they're supposed to write statutes for, is for fiction, for corporations. They write statutes for themselves, sort of how the process, how to write codes and way things work. And if you do this wrong, or if you do that, and you do it with, with criminal intentions, then this is the penalty. And all that is proper. US 42, US 18, some of that stuff under there is all proper. But when they get into what's called criminal law, that's no law at all. It has nothing to do with the common law. It has nothing to do with we the people. When they get into civil law, that's no law at all. It has nothing to do with us. But let's get back, and I'm trying to paint a picture here, and I want to get back to how we filed this paper, but we need to understand a little more about equity, and we also need to understand some other things on how we got here. But what we did, let's just finish with equity. Equity, they are supposed to rule accordingly, and they're not allowed to go outside this certain process and a way of thinking. The judges cannot bring their own intellect into the game. They must respond with American jurisprudence. And when their conflict comes and they're not sure which way to go, they have to always rule for the sovereign in the court, which is the individual that is being charged or the individual that has brought the case in. Okay? So in equity courts, you bring cases in. And now, the other thing our Constitution gives us is the ability to go into a common law court, not an equity court, as long as the value of the argument is over $20, 1 ounce of gold. Okay, now $20 or an ounce of gold is $1,400, but since they're afraid to say anything about an ounce of gold, it remains at $20, which whatever that value is, which is like probably 20 cents maybe or something,
Right.
But in any event, you can move. You have the right of jurisdiction, and all law says the same thing. You have 49 different courts out there, and if you can go into any of those courts and walk into that jurisdiction and run your jurisdiction and move into that court, as long as that court has the ability to hear that particular jurisdiction, you have the power, the authority, and you're a sovereign individual to be able to move that court in accordance to that jurisdiction. Now, there's only one court of law because there is only one God. Okay, there isn't 3 gods or 49 gods. There's one God, and that God wrote his law in the hearts of all men. So you can go to these 49 different courts with statutes written and ruled by men, and we may or may not give you civil rights, or you can go into the court of law, the one and only court of law that exists, where that's common law, natural law, that's God's law. Okay, so of course we've chosen that because we want justice, and God will give us justice. As long as that jury is not tainted, that jury will come out with the proper decision. And if they can't figure it out, they'll let the person go. If it is something where it's a criminal case or something of that nature, an injury, you know. But bear in mind, even in a court that is an equity court, people are injured, and that's why they're going to court. You know, a contract has been broken and someone got injured, so they're looking to be fixed. They're looking to get satisfied, and so there's the 2 differences between the court. You can go through very quickly if you have honest individuals that are putting forth American jurisprudence, ruling accordingly under the rules of the common law. You can trust that court to come up with the right decision. And if they make a mistake, you have an appeal process to go through. And so that works out pretty good. As a contractor, as a general contractor, and as a builder, I always preferred to go into that kind of a court. But it was very difficult to get through because the other side brings in this army of lawyers, you know, and they're the ones with the big monies, you know. So I've done different things, but the point is it would work from a perspective of a regular person going in with a complaint against another person or whatever. To go into an equity court is the quickest way to get through the process, get it over with, and move on with your life. And if they're giving justice, if they're meting out justice, then they're fine. Problem is they're not meting out any justice. They're meting out destruction and hatred. That's what they're meting out. So now we then move over to our case to finish off the point of our case. We have sent papers everywhere. We filed them in all 94 district courts, and they've done nothing with them. They're not there. They're not on record.
That's
so what
amazing.
are we going to do? What are we going to do? So let's go and open a case. We don't care if they call it a civil court case. I don't care what they call it, but we're going to get in there. And why? Because one of the things we have to do is get under the auspices of the court. So we put our pry bar into the door, we pried that door open, and we got our paperwork and we slapped it down on the table, and that's where it sits. And we continue to put it in, case after case after case. And what we're doing is we're compiling certain particular types of cases, okay, for a sole purpose of proving RICO on steroids by the judiciary in cahoots with the legislation and all of government in a whole. Now, again, everybody isn't guilty, but I think a lot of them are, you know. But nevertheless, they're the ones that have taken control. The deep state has seized control. They're guilty, okay. The judiciary is maintaining the status quo, and we prove it, okay. When you break the same law and use the same techniques and the same words and the same rules and everything's identical, and whether you go to California or to Nebraska or to New York or Jersey or Florida, or it doesn't matter where you go, it's the same thing. That shows a conspiracy. That shows collusion. They've done everything the same way.
Freaking treason, man. Yeah, I know. Exactly. Yeah, it's treasonous. Gotcha.
So we're going after these people. We have all these cases of non-judicial foreclosures, which is a crime. And the reason why they do non-judicial foreclosures is because these, first of all, whether it's a tax foreclosure or a mortgage foreclosure, neither of them have the power or the authority or the ability to win in a court of record because they have no real skin in the game to begin with. And they never did. They don't own that. That belongs to the person who owns it. It doesn't belong to them, never did, never will. And the whole thing was a con job that they created way back in the 1930s when they finally made us really assets, and all our assets, their assets, and called us chattel. That's exactly what's going on. That's when they started to, and this was in 1860s actually. And then they turned around and they required now the recording of births, Why? Because we're their property. That
Right.
birth certificate is showing that we're their property. That's what they laid up in the banks, you know. And so they set a number of rules up and situations, which really is going to hurt themselves in the long run. But it doesn't matter to us because we're not in their sandbox. We're not under their power or authority. We come and we speak in the power and the authority of the true lawmaker, and we call it for what it is, a fraud. And we've laid out in our papers over and over and over again, they had no power, no authority to create anything that was repugnant to the Constitution and think it's going to stand. No matter how long, I don't care that you've been building it up for 100 years. I don't care that you got 40 or 50 acts of Congress fortifying this whole process to come to a conclusion in order to bring us into subjection. It doesn't matter to us at all. It's all null and void. And you can't get in between God and the relationship with his people. And this is hard for a lot of people to swallow, unfortunately. People have been trained so long to get away from God and run away from God. You should be running to God. That's the only place you're going to get justice.
And that's a great point. And real quick, for our listeners out there, guys, this is John, and we also have Gerard here, and they're both founders of NationalLibertyAlliance.org. So please take a minute, go to their website. That's NationalLibertyAlliance.org. They have filed a lot of paperwork with a lot of different courts across the land. Okay, guys. So definitely check them out. They have a lot of good information that training courses that you can take for free. They ask for $5 or whatever you can afford a month if you can pull it. But seriously, go educate yourself, man. They've been subverting and weaponizing not only our judiciary, but they've been weaponizing everything. And real quick, while I'm thinking about it there, John, today some breaking news had come out with regard to the Inspector General. I don't know if you've had opportunity to catch that yet, but the Inspector General is actually now working with Huber, the newly elected prosecutor. And there is going to be criminal charges now brought up against folks of the DOJ and the FBI for the Hillary Clinton case and a lot of other things that the Inspector General's uncovered. So with that said, I'll let you continue on, but I just want to do a real quick break there for everybody out there listening. But check out NationalLibertyAlliance.org, guys. They're doing some great stuff. So, John, yeah, if you want to continue, feel free, man.
I appreciate that. One of the things we gotta know the foundation. I've spoken to lawyers and talked with them about the Declaration of Independence and how that is the foundation of our law. They don't recognize that. I mean, that's how far off base and out of touch they are. Our founding document, of course, is a law document. How could it not be? The founding document is the foundation of our Constitution. Without it, we wouldn't have the proper Constitution, because that actually describes the law of our Constitution, the Declaration of Independence. And what the Declaration of Independence really is, and if people don't want to believe what I'm saying right now, or they're unsure and they want to get real proof, I'll give you 150% proof. When you go to our website, on our front page, all the way down on the bottom, the last 3 videos, watch all 3 videos. You should watch all 4. I would say with the first, all 4 of them. There's 4 videos down there. Watch the last 4 videos on our website, and you will understand exactly how this nation was brought together and how we were brought under God, and you cannot separate it. For if you separate us from God, you separate us from our unalienable rights, and we are no longer blessed, and we are cursed. And remember, the preamble of the Constitution had given prime directives to our government on the process and how they are to proceed in law. And let me read this and listen to this very carefully. There are 6 things that every person in government needs to have an eye and focus on, and whatever legislation is written, whatever law is ruled upon, whatever decision is made from the administration or back over to the judiciary and the legislation, must be made with one of these points in mind and heart. And if they don't, then they're in violation of their oath. And here it is. We, the people of the United States, in order to form a more perfect union, point number 1, We came together to form a perfect union. A perfect union of the states is what they're talking about. With one law, the federal government to control that law. Establish justice, that's 2. Ensure domestic tranquility, that's 3. Provide for the common defense, that's 4. Promote the general welfare, that's 5. And the most important one is to secure the blessings of liberty to ourselves and our posterity. We do ordain and establish this Constitution for the United States of America. What people need to understand first and foremost, we are the kings. We ordained the law of the land here through this Constitution. And in that Constitution, we declared our unalienable rights, and we declared our right to justice in courts of law. And we can read some of that. You'll read that in Article 3. For instance, in Article 3, I believe it's in Section 2, the judicial power shall extend in all cases in law and equity. That's it. You put those 2 verses together, that's where you're at. And then the judicial power is controlled by one United States Supreme Court to enforce the American jurisprudence across the land in all of our federal districts. Now you got it all together as one piece. Now let's go to the real power of this thing. And this is the most important thing. You see, these people aren't just going up against the people. They're going up against God. And God is not going to be a happy camper about this. And Jefferson made a point about this. But we read, for instance, in Malachi. Well, before I say that, what the Declaration of Independence is a covenant between we the people and God. What we did is we want his blessings. We want to be a moral nation. We want to be a just nation. We want to be a nation under his laws, under your law, Lord. And in return, we'd like to have those liberties, the blessings of liberty. Did you notice there in the preamble? It's not the protection of liberty, it's the protection of the blessings of liberty. And we will continue to be blessed as long as we press towards the mark of justice and righteousness and mercy and the things of God, to be morally minded. Okay, and let me tell you something. When you go look and read those, when you hear those four videos that I'm talking about on our front page, down on the bottom, that's going to solidify and confirm what I'm talking about right now. And there is nobody, I don't care if you're an atheist, you won't be able to deny it. You may be able to still deny God. That's your unalienable right, and you're welcome to dwell with us. You read the Bible, God has always welcomed the outside people to dwell with them. If they want to live under our rule, yay, come on in. That's what America is all about. We're the second Israel, okay? Right. But the bottom line here, we made this covenant with God. Nobody can break that. If these fools think that they can walk in, subvert our legislatures, and subvert our courts and our judges, and think they're going to get away with it now that we're exposing and shine a light on it, justice is coming, and it's going to come heavy. And,
and I'm really glad you brought that piece up, because as we're seeing, right, and I'm sure you've been up on these Q drops and military intelligence feeding We the People. So we're constantly reminded about being patient. Okay. We're also reminded. Yeah, exactly. We're also reminded that trust the plan, right? And the plan is, they've spent, I don't know, generations now, right, putting all this crapola together, subverting the judiciary and everything else that they can. We know the power people, the 1%ers, the cabal, the whatever you want to call them, they're putting their money behind people, getting them into office, using them as puppets. Right, we know this is going on. We know it's been going on. Everybody's went, arms in air. Well, that's just the way things are. And been so complacent. And of course, I've been encouraging everybody that I talk to is that come these midterm elections, guys, it's time to get up off those freaking couches, okay, and get out there and vote. Do not use those machines. Request paper ballots. Go and vote. Everybody needs to share this with everybody they know, okay? Because what we need to do is take back our country, take back our sovereignty, okay? These people have subverted and weaponized all of these things against us, we the people. And what John, Gerard, and a lot of other folks over there, National Liberty Alliance is doing is that they're going directly at the judiciary to the point where they can't really deny what's being filed. Right? They cannot deny it. Like he was just saying, they don't want to put their fingerprints even on the paper. Okay, like they've looked at it. Plausible deniability at that point, I guess. Or let's go ahead and hang out the little guy, which in this case would be the clerks, right? Let's hang them instead of the judge, because the judge will get 20 years, you know, if they're found subverting the Constitution. So, I guess it's really great meeting you first time here, John. And you brought a lot of really, really good information to people that otherwise would not know. And it's definitely appreciated. And again, everything we do at Q-Universe, man, we're definitely going to support you guys, everything you do, man. I mean, I really, really, really appreciate you guys, man, and all your efforts. And I know a lot of people out there, you know, are popping off questions, you know, as you've been talking. And I kind of didn't want to interrupt you because I know it's a flow process.
Well, give me another 5 more minutes and then maybe I could take questions.
Yeah, sure. Yeah, we can do that.
I just want to finish this major point, and
sure.
And we're building up on where we've come from, what law we're under, by what authority, and how they cannot just take it away and subvert it away. They may think they can, and they think that they've done this in I think it was 1939. They think they've done this in 1949. They tried to subvert habeas corpus completely here in New York, and it went against them because the people stood up and recertified, regurgitated the fact that we, the people, have a right to habeas corpus, and they even put the point that it'll never be taken away. It's part of who we are as a people. So it actually went against them there. But in 1939, they subverted the whole court process, the whole judicial process, and the way things work. They did that through the rules of the court when they came and wrote the rules of the court themselves. And then set off the chancery courts in place, which gave room for them to move with a lot of things, a lot of different structure or law construction of acts that go all the way back to the very beginning, as I mentioned, to the Judiciary Act of 1789, right in the beginning, the birth of the nation, all the way through up to date and continued onward, you know. But anyway, here's the main thing. We made a covenant with God, and that solidified it all. No man can break a covenant between the people of God. At some point, his anger and his wrath is going to come down upon them, and they will wish they were never born. And, you know, and I feel compassion for them for that, and I feel merciful for that, but I also know that they deserve it. But in Malachi chapter 3, verse 8, God said, Cursed are they that rob God of his nation. And he was talking not only about the nation of Israel, and this is after the nation of Israel, by the way, but not only the people who have subverted that, but also the people who have subverted his nation here, being the United States of America. And Thomas Jefferson said, I tremble for my country when I reflect that God is just, and his justice cannot sleep forever. And most people believe we are at the end days, and a lot of people believe that the judgment God is going to come upon this world like it's never come before, and men's hearts are going to fail for fear of that which is coming upon it, which is the wrath of God. So this is the power and authority by which we come. You know, we are little David, okay, going up against this great big Goliath. We do not have a chance of winning this thing at all. Without God, that is. With God, all things are possible. And, you know, David, you know, when you read the Bible, who is this guy Goliath? I don't care if he's that big. I'll take him down because I believe God's going to take him down. It's not going to be me. It's going to be him. And he throws this one little pebble into his head and he's done. Cuts off his head and takes his sword, you know?
Wow.
Well, that's where we're at. We're going to cut off the head and take their sword. You know?
And that's awesome, man. And, you know, again, John, I mean, you're full of so much information, man. We're just a delight to have you guys on, man. Really, you and Gerard and the rest of the crew. I mean, the concept guys behind We the People. Okay, that's what this whole country is founded on. We the people, and it's gotten to the point where, you know, our government has more or less become some big, you know, corporation business that's corrupted by ugly money, ugly people behind the money, and so right now, you know, we actually have hope. Okay, guys, we have a president that really does care about this country. Okay, we have military intelligence that has actually been very aware of the different things that have been occurring within this country for many, many years, probably a lot longer than we all know. And with the efforts of National Liberty Alliance, John, Gerard, and so many other people, right, we're going directly at them. And as John's mentioning, you know, you're trying to go against God here, guys, and that's just not going to play out well for you, not on this plane or any other plane that you find yourself on. So, again, you know, there's this subversion that's going on with the legal system. There's subversion going on with how our bills are written. There's subversion based on elections. I mean, there are so many things. We can continue on. I mean, we've got cures for ailments that's been killing all of our loved ones. Okay, they keep those from us. They keep us tied with the pharmaceuticals. Okay, lobbying, right? They name it lobbying, right? You know what it's called? It's called bribery. All right. If you try to slip a cop $20 to make the ticket go away, you go to federal prison, guys. It's called bribery. You can't do that. But they just rename it to something different, and they call it lobbying, and they let all these clowns into our capital where our laws are supposed to be ratified and made and signed off on, right? And they get all this ugly money up in there, and then guess what? It's no longer for us, we the people. It's all for them. And I'll tell you another thing that they do. Okay, they not only do that, and they put these puppets or these elected officials, if you will, into office, right? But you know how they get the paybacks? They actually create these things called grants, if you guys never heard of them, okay? These grants get squeezed into these bills, you know, on page 4,227 as an example. Okay, on that particular page, okay, is this grant, and we the people never know about this grant, but you can be rest assured behind closed doors, the people that got them in office know all about this grant, and they can, through one of their foundations, go collect this money from we the people. Okay, and these are the types of things that have been used against us, we the people, for so long. The Landmark case. And unfortunately, we've been going about 2 hours now. But the Landmark case is something I would like to bring you back, if I could, John, Gerard. I would like to just talk about that. I would like to talk about what it is you guys done, what has happened since what you guys have done with the filing. And I also know there are people that in this same case, filed under the same case, there are people, Lavoie, who is murdered, and it looks like he was murdered for his land, and it looks like it's recently come out that those ranchers down there, their land was pretty rich in uranium, and we're putting together the idea in our head this was the overall motive from the get-go, but I don't know. I could be reaching, but I would like to bring you guys back and have a real low-level discussion about it.
Yeah, fine, anytime. We have a lot to say, and we can't cover it in 2 hours. We can't cover it in 20 hours. It takes time to really get all these things out, to build the foundation for people to have the knowledge and understanding and the ability to exercise their unalienable right of government by consent, because right now we don't have government by consent, but we can have it. People first have to believe, and you believe. Education is the key part of that. Remember, as Jefferson said, if people expect to be ignorant and free, they expect what never was and never shall be. So you're not going to be ignorant and get this and get freedom or liberty because you don't even know what it is. People don't know what it is. They don't understand it. When you start to discover some of the things that we've discovered and that we're teaching, it's just going to blow your mind, you know, what liberty really, really is. But let me just say this one thing, and that is that we need to go after the judiciary. We need to go after them now. We have all of the evidence we need to take them down. We need to combine that particular case. We need to combine not only against the judiciary but also against the Bar Association. It's the Bar Association that's pulling the strings of both of our legislators and also the judicial process and also our money, the banking system. So they control all the real powers. That's where the real power is. That's where we have to take it all back. We have to take our money back, and Congress needs to understand that the government needs to coin the money and only make gold and silver the money. And we need to understand these things, but you can't do it without knowledge, because you can't debate them, you can't argue them, but you can overwhelm them with truth and just turn that light on, and they don't know what to say. Look, every time we take these people to battle, after a while they just go silent, because they keep sticking their foot in their mouth over and over and over again. And we always know we're going to have the best part at the end of the day, because we know we're standing on righteousness, and what they're doing is a lie. So we need to do this. Now, if a group of lawyers or a group of people would hire lawyers or get together to try to do what we need to do, it would probably cost easily many hundreds of thousands of dollars in legal fees alone just to get this done. Okay, we can do it for maybe $5,000 to $10,000 at the most. For $5,000 to $10,000, we can take this whole system right into the courts, and we can go after the United States Supreme Court. If after we give them our writ of mandamus and they don't obey, we'll give them 5 days to obey. If they do not obey, then they will be in our sights also as a potential indictment against these people up there on the Hill, and we will go after them as part of the judiciary, and they need to be taken out. We need to replace them all. They need to be sent to jail, not home, sent to jail. And we need to replace all these people. So that's what we need to do, and we need the support of the people. It costs money, but we're not looking at hundreds of thousands of dollars, and we're not looking to get lawyers who's going to make a deal in the back room. At the end of the day, they already know they're going to lose. They won't tell you that, but they know they're going to lose. Well, we can win if the people are behind us, and we keep pushing. And what are they going to do when we come in and they realize that they can't put their judge in our courtroom? You know, we're looking into that on how we're going to go about that part of the problem, and hopefully next time we talk, maybe we'll have that answer. But we're not going to allow a judge to sit. And first of all, they have to sit as a magistrate, not a judge, which means he's only a traffic cop. He doesn't get to make decisions. But if you want to take questions, if you have time, or are we over?
I want to make a quick point here, or what John mentioned, but I think people have to really understand that when you, even like in an equity court where you agree to let the judge make the decision, right? He doesn't give his opinion. He rules according to law. And when he makes a decision, you say, by what authority do you make that decision? Well, the authority is in the law. So he's not allowed to have an opinion. He can only rule according to American jurisprudence. So if it's his opinion, and they'll tell, some of these judges are stupid, I think, I don't know. They believe that they can rule on their opinions. It's up to the people to know that they can't. Now, one of the things that there's a quote that comes from Samuel Clemens, who was Mark Twain, that I love, that kind of points this out, and it's part of what our problem is. He said, "It ain't what you don't know that gets you. It's what you think you know that ain't so." And that's where we're at. These guys are operating on things that they think they know that ain't so. So it's up to us to, and those are the ones that we can educate. The other ones are just pure evil. They know what they're doing. I believe there's a faction up there that absolutely knows what they're doing, and they know what side their bread is buttered on, and that's why they're doing it. And those guys, we got to get rid of them.
Wow, that's a pretty good comment. And with that, guys, I think we can move into a couple questions. Let me make a couple comments, and that is, with the idea that it seems like we're in this battle, this back and forth, if you will, with trying to remind our own judiciary really what this legal system is. And I believe that a lot of them that's been doing it forever and a month, they've just lost their way. They just actually started believing the own stuff that they've all formulated over time. And so, again, everybody that's listening, it's about our Constitution.
Their conscience has been seared. That's the problem. When they got their education, they came out as bar lawyers, their conscience has been seared. And that's a very important point to understand, and maybe next time we'll discuss that in a greater level if you remind me.
Right.
They also help with the perks that they give them. That right away it covers their conscience, because they definitely get perks every time they hammer that gavel down and put somebody in jail or make
Right,
them.
they feed the flesh with money, with dollars.
That's right.
Right.
So that helps them keep along that path. And I always notice that when we get to a certain point with, especially like a lawyer or judge, they may not know everything you're talking about, but instinctively they know they can't go there, because when it comes to the money, they know that that's going to damage them. They don't even have to think twice about it. It's almost like a knee-jerk reaction for them.
Right.
Well, it's like a serial killer. You know, look, a serial killer doesn't really think about right and wrong and what they're doing, because they have something invested in whatever it is that they're doing and how they're torturing someone or whatever it is that they're doing here. But the point is when they're forced to face it, they will admit to you they knew it was wrong. Yet they did it anyway. Why? Because their conscience was seared, and they just don't give any thought or concern about the consequence or what it is that they've done wrong, right up until the day of judgment. They don't care.
Right. And so with that said, I just kind of want to bring up a couple items for you guys. I know that you guys are hard at it. You're constantly filing this stuff. You're constantly going to court and dealing with all this crap, for lack of a better term. And I'll keep Ken. But the thing is, like right now, we have Gorsuch that's just been put in, of course, to the Supreme Court by our president. And I'm going to go on the record here, and I shared this with Gerard. I believe
Maybe we'll appeal to him when we write to them. But go ahead.
Yeah, that's why I'm saying it out loud, because I'm fairly certain Q, the president, military intelligence, they're aware of us. They're completely aware of us. And so this would be a direct message, and I believe this is going to come to tuition. And that is, there are going to be 3 more justices, okay, that's going to be stepping off the Supreme Court. We already know Justice Kennedy has announced this spring, and it happens to be spring, he's going to be retiring, okay? I believe there's going to be 2 more, okay? And those 2 very well could be people that I could be getting it wrong, I could be getting it right, but I believe Sotomayor is going, and I also believe the little one, her name escapes me at the moment.
Ginsburg?
Thank you. Yeah, Ruth Bader Ginsburg. And I believe by the end of the president's second term, that what's going to happen is he will have put 4 justices on the Supreme Court. So with that said, let's go ahead and take a couple questions. Like I said, we've already went over the 2-hour mark, everybody. So if you guys have a specific question, please feel free to throw them out there, and I'll share them with John and Gerard. Okay, so I'm going to scroll up just a little bit. Give me just a second, guys. Yeah, so some people are commenting, John, that this is the missing piece of the puzzle, and I would have to agree with that. For a lot of folks, the notion that we're running under a subverted legal system kind of surprising to a lot of folks. You got a comment about that?
Well, absolutely. Look, at what you have to understand is the Rothschilds. Okay, go to the father, the beginning. One of the things he says is, "Give me control of a nation's money, and I don't care, anything about anybody else's power." I forget exactly how he said it or what he said. But is it the laws? Okay, yeah. But it doesn't matter to me. He can maintain control. Well, that was a lie, really, because if he can't control the courts, he really can't control the nation, okay? And you could pay off everyone you want, but if justice is made aware of it and justice is still available in the courts, these people are going to go to jail. And I'm sure he didn't want to speak too much about it, but he had to take over the judicial system. Therein, he had to send out minions, and the minions is what we know is the Bar Association. The Bar Association has created this whole thing. They have subverted us. They teach subversion to their lawyers. None of them know anything about the law. They're completely, totally ignorant of the law. But they think they know the law, and it's called statutes, and it's really chancery law, or whatever you want to call it there. But it has nothing to do with we the people. And if people need to understand, they can just say no. That's what we need to do. We have the power. to shut them down and deny them and say that's not the law. You know, it's nullification, nullify it. That's what the president should have done. Nullified what that judge said. Tell him to go to hell, and should have did. He shouldn't have waited. He should have went, but he didn't know. You know, he's not perfect, and none of us are.
I got you. Okay, so let's see. QSMX pilot saying that Judy Home asked, "How do the military tribunals figure into all this stuff?"
Well, they really don't figure into where we are in courts, but because it is subversion, because it is really war, they have warred against the Constitution. They've warred against the people. They've destroyed millions and millions of lives. Think of all the wars they've created, all the poverty they created. They crashed the economy. They control everything. All the people have gone in jail, because the status quo had to be maintained and all that. So that is war. And because you were at war, the president does have the power and the authority. It'll be a quicker justice. We know how it should end up anyway, so I'm good with it.
Yeah.
We have a quicker justice for him to do a military tribunal and bring them out of the country and deal with them out there, and I'm good with that because they are the real terrorists. That's who they are.
Look, he just put in a ex-JAG as the chief prosecutor in New York City, John. Down in Brooklyn and New York City, and I think there's a reason for that. Now,
yes, sir.
They're going to get indictments through grand juries here. That's where we figure in. As far as the military tribunals, the reason that Trump and the military feel that that's necessary is because they've had so many years and they've subverted so many people in the system. You couldn't do it here. You could never get a conviction against Obama with all these people that he put in. Look, not only did he put them in, he made sure he had the goods on them. They know what these judges did. They supplied them with maybe the child or whatever they're doing. And so those people are going to do whatever they can in court to stymie that trial. That's why it needs to be done with a military tribunal.
Yeah, it'll be a circus, and I agree with this. Look, we're at war with these people. We got enemies, foreign and domestic. They have committed subversion against the United States of America, and as I mentioned, they have destroyed lives. They deserve justice. Deserves to be held heavy upon them. And again, that's why in these cases here, I have no problems, and I think it's very, very correct to do it this way, is to put them under a military tribunal justice and let them decide what they're going to do. They can hang them out there in Cuba.
Yeah, and I would actually add to that is that the military tribunals also primarily is for the level of treason that's been committed against this country. Right. You're not going to really prosecute treasonous people, in a regular court, right, with the way that the courts have been stacked, right? So under a military tribunal, and we know what the maximum penalty for treason is, and that's death, okay? And so I believe that's another good reason a lot of these people, and we're approaching 30,000 sealed indictments across the nation right now. 30,000 people, and that's significant. I mean, the average right now, I think they said, is somewhere between 1,000, 2,000 sealed indictments that may appear on combined dockets across the nation in a single year. Okay, and this has actually been going on now for since President Trump had been elected. So we're approaching 30,000. I'm actually presuming we're going to get a lot higher than that. And we got time for a couple more questions. So specifically, Mako Powell asked, what year was the bar created? If anybody knows that offhand.
The New York bar, not the New York bar. The New York bar was created in the 1900s, early 1900s. But the bar actually came into being and started to build itself. I think it was in 1860s. I'm kind of breezing through some papers. I may have the answer here. So if we go to the next question, if I find the exact year, I'll pipe it in. But I think it was 1860s.
Okay, about the 1860 time frame. I got you. Okay, and so I guess I'm looking. Okay, so somebody's got a statement in there. It's not a question. It's a statement about SES. It's the portion of the government.
1878. In 1878, the American bar was created that provided for the homegrown minions of the Bar Association here. Prior to that, it was, let's see, they sent them from England. And as a matter of fact, let's see, in 1861, the bar, under the color of law, convinced Congress to pass the Revenue Act. In 1862, the bar covertly solidified under the Revenue Act a corporate Congress and changed the meaning of the word person, deeming it to mean corporation. So you see, they've been working and really chiseling our whole process of law and our process of government way back when.
Wow.
There was one other thing that I wanted to bring up here, if I could find it quickly.
Sure, I'll just keep looking.
Go ahead.
Yeah, and so let's see. We've got one more from Andrew Zebron III. What about Nasera? I'm not real sure what Nasera is personally, but
yeah, I don't know.
Okay, so that's a tough one. Okay, so bar came into being in 1878, but anything bad for the U.S. after 1913? Okay, good.
Here it is, 1845, okay? In 1845, the Pope and the King of Britain set out a covert action and issues letters of marque and reprisal to the members of the Bar Association, that was the British Bar Association, allowing them to act as foreign agents on American soil and as privateers free to plunder American commerce, okay? And so it goes on, the bar minions of the New World Order infiltrated Congress and through the use of legalese covertly succeeded in fraudulently replacing the republic with a democracy, our laws with statutes, and thereby turned we the people into subjects and chattel and changing the meaning of words such as persons to corporation. This was accomplished by covert legislation and rewriting of history with propaganda, and by this means created what we understand and call fiction of law. And the definition of fiction of law given in the United States case, case, Ryan versus Motor Credit Company, something known to be false but assumed to be true. So yes, and you know, I'm reading these notes out of the brief of Amicus Curiae that we're going to be filing probably tomorrow or the next day, and we'll be posting it as soon as we get it filed. We'll post it up on our website,
very good.
and we'll be sending out emails. So you get our emails, you can announce it to the people here or anybody else that becomes a member. They'll hear about it, but you know, there it is.
All right, very good. Okay, so I guess we'll take one more final question. Let's make it a good one. Okay, so we're told QSMX pilots telling us National Economic Security and Recovery Act, which is NASERA. Okay, thanks for that. And finally, question, I missed it. Hang on, I'm trying to find it, guys. I saw one more. I thought it was a good one. I'm scrolling for it. I'm not seeing it. All right. Well, unfortunately, I missed that one, guys. So
I'd like to say one thing here.
Yeah,
Lincoln
sure.
Hall just said, if this legal action starts in the U.S., it will eventually spill over to other countries and benefit them as well. I want you to know that there's only like 5, correct me if I'm wrong, John or Gerard, there's only like 5 countries in the world that practice common law.
There's only one country that has the perfected common law, and that is the United States, second to Britain. Because they've got the Magna Carta, but they don't have a Bill of Rights, and that's what they're really missing. And the Bill of Rights is what really cleans up all problems. Jefferson was brilliant, and even though he didn't write the Bill of Rights, he was behind the Bill of Rights. All the ideas and thoughts, and it came really a lot from Jefferson, and he fought for him, you know, tooth and nail, saying the people had to have the Bill of Rights. And what the Bill of Rights done is it didn't matter what errors or mistakes that we might have made in the Constitution, which I find very few, and the ones that are there really don't affect us these days. It's the slavery situation. But other than that, you know, even anything they try to do that is repugnant to the Constitution, particularly any of our unalienable rights, not only just defined by the 10 amendments, but we have a lot more rights than that. But
can I say one more thing?
Yeah, but nevertheless, when you use the Bill of Rights as a yardstick, a ruler to measure up, to see if this measures up to good law or not, if it's repugnant to our unalienable rights, it's null and void. And that's the genius. Those
That
Bill
is
of Rights
genius,
is what has kept us from really falling into total disaster a long time ago.
and thought about it back then. I mean, that's phenomenal.
Yeah.
So
One more point,
Mhm.
and that is that all those other countries have a system that our justice or judicial branch has been trying to move us to. And that is all that Babylonian, Justinian's Code Rome, the canon of the Catholic Church. That's what they've been trying to move us to. And that all the rest of the world, that's what they have to put up with, is what we're starting to feel, or we've begun to feel over the last 100 years. And it's the common law. People say that America is not unique or exceptional. The common law is what makes it exceptional over
That's
just
right.
what you just said.
Well, lawyers will tell you that we're under Roman law. They will actually say that, and that's an amazing statement that they would say such a thing. But they claim to be under the Roman law. Now, Roman law came from Justinian law, and Justinian law came from Babylon. Babylonian law is statutory law to control the people, to keep the people controlled as slaves and as chattel. And then what Justinian did is all he did was take it and package it in a different way, and then it eventually was sold to the Roman Empire, who applied it as law. And yet they claim that that's where their law comes from. The idea that it's civil law, the word civil identifies with statutory, and therefore it is statutory law, and lawyers have no problem. And you can read on the internet when you go looking for some of these things and trying to understand the law, where it comes from, or this or that. They have no problem talking about the fact that it comes from Roman law, which leads them right to Babylon.
that's interesting stuff. All right, guys. Well, look, I'm going to go ahead and wrap this up. I definitely appreciate you guys joining us. John, great meeting you. Gerard, we're definitely going to be talking more. And everybody in YouTube, we definitely appreciate you joining us also. Sorry I couldn't get to all your questions. We just kind of, ran out of time here. But effectively, what we're going to try to do, National Liberty Alliance has filed some landmark cases, okay? And really, guys, you've got to dig into this and see what great stuff these guys have done. It's blown the minds of many, and it's going to continue to do so. They filed with everybody from the local courts all the way up to the Supreme Court, and everybody's aware of it. It's on the radar, guys. And so with our help, we can help out National Liberty Alliance, guys. We can keep them, and like he says, they don't need tens of millions of dollars. They're just looking for a couple few thousand to get this stuff filed. Because the courts charge you for sneezing anymore. So let's go ahead and try to support them if we can. Guys, again, thanks a lot for joining us, and you really helped shed a lot of light on a lot of things people otherwise would not have known of. And what I'll do is I'll go ahead and I'll publish this video in its original form very soon. And so feel free to link to it. Feel free, everybody listening, to share the link wherever you go, and let them know that common law is coming back, and the subversion is going to be taken care of. And with all the weaponization of all the different systems, and I hear a lot of people from time to time saying that nothing's being done here, nothing's being done there, nothing's being done here. Well, that's all BS, because guess what? There is something being done, okay? And you know who's doing it? National Liberty Alliance, guys. And you just now got to meet both the founders tonight. And again, guys, I'd like to thank you both for taking the time and sharing all the great efforts you guys are putting in towards this.
Well, thanks for having us. We appreciate it.
Yeah, no problem. Okay, guys, everybody YouTube, stay tuned. Make sure you click the little bell here on the website. If you haven't done so already, you'll actually receive the alerts for the next special reports that we pull out. So make sure that you turn those notifications on, people. And anyway, until next time, this is iNet Coder of Quniverse, and we're thanking our guests again from NationalLibertyAlliance.org. All right, guys, till next time.